In this scenario, I will serve as Jackie Jones, the plaintiff. Jackie was treated at St. Ashford Hospital where an employee, Beverly, did not follow minimum necessary requirements and left a telephone message with Jackie's daughter. The message detailed Jackie's medical condition as well as her treatment plan. Jackie gave instructions to contact her via her work telephone number. Beverly did not follow those instructions and left a message on her home telephone number instead. The Office of Civil Rights, which has the duty of implementing and enforcing the privacy rule, conducted an investigation and further found that Beverly did not follow confidential communications procedures. Beverly, along with St. Ashford Hospital, are considered covered entities under HIPAA definition. These covered entities are required to adhere to the privacy rule and its regulations in regards to protection and privacy of personal information. The Privacy Act of 1974 states that no agency shall disclose any record which is contained in a system of records by any means of communication to any person or to another agency except pursuant to a written request by or with the prior written consent of the individual to whom the record pertains. No written request or oral consent was given to Beverly to disclose information to anyone other than Jackie herself. Jackie is a competent adult who speaks and makes decisions on her own behalf. The information that was disclosed is considered protected health information, or PHI, because there would have been identifiers such as name, address, birth date, or social security number that were in the message that would link Jackie Jones to the specific PHI that was disclosed. Furthermore, the PHI that was disclosed was not necessary for any public health, abuse, neglect, or any other emergent or important purpose. According to the U.S. Department of Health and Human Services, a breach is defined as an impermissible use or disclosure under the privacy rule that compromises the security or privacy of the protected health information. Jackie's medical information was disclosed without authorization to her daughter, which would constitute a breach that compromised her privacy. The Department of Health and Human Services has issued regulations requiring that if a breach is made, the affected person be notified promptly of such breach. Jackie was never notified of any breach by either Beverly herself or St. Ashford Hospital. Jackie's request for her information to be communicated through her work telephone number was a reasonable request and met the criteria for the confidential communications requirements set forth by the Department of Health and Human Services. Some healthcare providers offer their own form of authorization of disclosure of medical information that requires that the patient read, detail preferences such as telephone numbers to call and whom to speak to, and sign. These forms are kept in the patient's record for those accessing the record to see. There should be a mandatory training program and a mandatory review of patient contact information to help alleviate these types of problems. I have found a form that is used in a hospital that gives patients an opportunity to clearly state where to call with confidential information and what type of message should be left. It also allows the patient to appoint another family member that is authorized to receive medical information on their behalf. I have attached a copy of this form to the discussion forum. Jackie has the right to control her own healthcare information, and in an attempt to do this, she instructed that communications come to her work phone. However, those rights were not upheld when Beverly called her home phone and left a message with Jackie's daughter against her instructions and wishes. Jackie's privacy was violated by this action. Her trust and confidence in St. Ashford Hospital, or any other hospital for that matter, has been shattered.
Okay.